So just a quick background on myself. My name is Mark O'Brien. I am a estate administration attorney at Cope and Barger. I've been doing this, and when I say this, probate administrations, trust administrations, conservatorships, guardianships, probate trust litigation, and then all the related tax transactional work, corporate and real estate transactional work for the past about 12 years to various capacities. I spent most of my time in law firms in Orange County and LA County, but I've worked with with trustees all over the state, worked with clients all over the US, as well as a couple of cross-pond and international administrations. Just a little bit of background on myself, so you can get a little familiar with me and who I am and what I do. So this is kind of just a brief overview of today's agenda. We're going to be talking very briefly about the grief and responsibilities, how complicated and how complex it is having to deal with losing a loved one while simultaneously having to do a probate administration or do a trust administration, and why, having people and having things set in place to help you can also help the grieving process. Within that discussion, we will go through estate administration duties. Estate, for these purposes, is going to mean a whole bunch of things. It's going to mean trust administrations. It's going to mean probate administrations. It's going to mean conservatorship administrations. It's going to mean when someone's incapacitated. There's various iterations of this. Like I said, we'll go through each one of those in much greater detail. Just want to give you a framework of what we're going to be covering this afternoon. We will also be going over some timelines, what a typical administration looks like, what the length of that looks like, what factors will affect the timeline and what to expect from an administration standpoint. Communication and expectations. This is often an overlooked aspect, but probably, in my opinion, one of the most important aspects. What is, when you create a trust, what are your expectations of your successor trustee? Beneficiaries, what are your expectations of the trustee? If there are co-trustees, what are your expectations of each other? And then also what that communication looks like, how often you're communicating, what does a trustee have to communicate to beneficiaries, what do trustees have to communicate to each other? If it's a probate administration, what does that communication look like with the court, and so on and so forth. And then, really at any point, I'm going to be going over as much in detail as possible, but obviously there is no specific instance. I'm not working with a specific case here. So if you have particular questions, you can throw them in the chat. And at the very end of this, we'll be letting you know that you can always reach out and schedule an appointment if you have a specific matter that you want to address in greater detail. And that lastly kind of ties in with how our firm can help with any type of scenario, and I'll get into greater detail as we kind of progress through this. Here's just a brief overview of the other attorneys that I work with here. We have a very wide-ranging team of people who specialize in various areas: estate planning, estate administration, business, tax, litigation, and other related areas. So just so you can kind of have a better idea of the people that are at our firm and who you'd be working with. Again, just a picture of a lot of our staff to get antiquated and kind of feel familiar with us. It's always nicer, especially when you're doing webinars and doing things over Zoom, as everyone here knows, due to COVID and pandemic. It's always nice to have a face to the phone and to meet in person when it's applicable and available. Okay, these are just some of our locations. Myself, I'm in the South Coast Metro. That's the main office here in Orange County. We have various other locations. If you have family members, friends, loved ones who are in any of these areas, we are more than happy and more than willing to assist them with any of their needs and desires. All right, so we're going to kind of get into the thick of everything now. This is really where in the overview of the presentation kind of takes its beginning point. Like I said, we're going to talk about the grief and responsibilities and how planning ahead can really alleviate concerns, really set some parameters and guidelines for what to expect and how to navigate this process. It's an extremely difficult time when dealing with a loved one, as I'm sure a lot of people who are attending today have either have experienced having losing a loved one, or have heard horror stories from other family members or friends about someone who passed away without an estate plan, or maybe they passed away with an estate plan, but there was litigation, or other issues that came up, or there was a lack of communication between the attorneys and the client, and they didn't really realize what they were expecting. The fees weren't articulated. The amount of work that was, wasn't really articulated, or generally just not enough communication within their own family and what the, who's going to be the successor trustee, what that's going to look like, what the responsibilities are, and so on. So kind of looking at this, I think everyone has a fundamental understanding of the topics that are bullet pointed on this particular slide. It's very difficult when you lose a loved one. There are multiple stages of grief, and everyone grieves differently. Sometimes, we have clients that a loved one or family member passes away, and the next day they're calling us saying, "Hey, I'm ready to administer the trust." That type of typical person is, taking the approach of, I want to get this going. I want to keep my mind busy, so that I can kind of move through this, and I want to delay the grieving process. Some people take quite some time to, really pick themselves up and really, start to administer the trust. Everyone does it differently and everyone handles it differently. And that's why having a plan set in place really makes this transition easier. It also smooths out things depending on what your family dynamics are. Do you have multiple kids? Do you only have one child? Do you not have any children? Are you married? Are you not married? Blended families? Are you leaving assets to charities? Are you leaving assets to non-blood friends, and distant relatives? Just anything and everything is going to come up, and anything that can be done to make that process easier and to allow you to grieve is really, at least in my opinion, one of the huge overall benefits of having an estate plan, and then also making sure that you have an idea of what the trust administration, probate administration, and any type of estate administration looks like moving forward. Okay. To go along with what I was saying, really planning is the number one thing that I'm going to harp on. Knowing these processes, at least just hearing them at a surface level, one time, two times, three times, makes the process easier. It also allows you to have a better understanding of, okay, who do I want to be my successor trustee, right? Who is going to have the best capabilities to follow my wishes? Sometimes people will default to, okay, my eldest son is the oldest, or my middle child is the most educated, or in my opinion, the most uh, intellectually sound, or most financially savvy. And sometimes that's the best case scenario when trying to choose someone. Other times it's who is actually going to abide by what I want done, who's going to see out the terms of my trust, who's going to abide by my wishes and my desires for my legacy. And sometimes that's actually the best person to move forward with. And then setting up the appropriate team and the right individuals around that family member to be able to help them and to help them assist in the administration. Again, while they are also grieving, the loss of their own loved one. So like I said, there's a lot that goes into us. Even in a trust administration and a probate administration, there's a lot of legal complexities, tax complexities. There's a lot of busy work that needs to be done by the attorney's office, by the client, by the CPA, potentially by financial advisors. So it's always good to have a solid plan set in place. And then also to keep that plan up to date. We have clients who put a great plan in and then don't come back for 20 years. So many things have changed in that time. It's always good to, even if you don't come and see us, it's always good to sit down and review your plan every 3 to 4 years, to ensure that, one, everything's still the same. Two, to make sure that, it's actually going the way you want it to. You may not want this person to be your fiduciary. You may not want this beneficiary to be in the trust anymore. So it's always good to reconcile that by reviewing it and calling us to sit down and review everything, even if no changes are ultimately made. Okay, so we'll kind of go into trust administration duties, the role of a trustee, right? So what happens to your loved ones? Who is the trustee? What are their roles? Who are the beneficiaries? Will they be involved? These are all very open-ended questions, but I'll kind of briefly go into just like how these play out in the various iterations here. So right? I can create an estate plan. You can create an estate plan. You are in control, right? Us as the attorneys, we can advise you, but we are going to draft it based on what your desires are. We can tell you what the law is and what you can and can't do, what needs to be in the trust, what can't be in the trust. But ultimately, the decision stops with you. You're going to be the one naming your trustee. While you're living, most of the time it's going to be you. But what happens when you become incapacitated? Further, what happens when you pass away? On top of that, do you want that to be the same individual, right? Do you want the individual who's going to be administering and taking over your estate from a financial perspective when you're incapacitated to be the same person when you pass away? It could very well be that it is the same person, but there may be someone who's closer to you from a geographical physical standpoint that you may want to be taking care of you while you're incapacitated. And then you may want someone who may be out of state or further away and can't necessarily get to your physical geolocation. Once you passed away, that's not as important, especially with technology and all of the remote capabilities that we have communication wise. At that point, it's not necessarily as important. That's something to think about. Other things to consider are what are the roles of each individual? What will they be doing? Right? Who are the beneficiaries? Sometimes, there's going to be a beneficiary who is also the trustee, right? If you have two kids, you may name one of them or both as trustees, but we'll kind of go into the difficulties of having co-trustees a little later on. But those are all things to think about when you create an estate plan. And then, like I said, the beneficiaries, will they be involved? You could have an instance where you have 10 children, right? Do you want to name all 10 as trustees? Probably not. I don't know many practitioners who would support that type of a decision, right? You usually want less cooks in the kitchen. And I'll get into that to a greater detail as we kind of progress in the presentation. Okay, so the role of the successor trustee. Just some definitions and kind of overviews here. EA, that's short for estate administration, is an estate administration, right? It's really the process of what happens when someone passes away. There are judicial and non-judicial administrations. All that means is there are administrations that involve the court and the court supervision, and there are ones done outside of the court, right, without court supervision. There are different, most of the time, I would say just from a privacy standpoint, a trust provides the ability to do it outside of the court's purview without any court approval, without filing documents to the court, which most of the time is public record. So there's a big privacy aspect to having a trust administration. A successor trustee, right? That's the person, the individual or the entity that you're naming to be responsible for making sure the assets are distributed according to your wishes, right? That's a very broad duty that a successor trustee has. Now, a successor trustee also has to do all types of other duties, a lot of other responsibilities, a lot of other tasks that they're going to have to do. But ultimately, their end game goal is to distribute the assets pursuant to your wishes as you set forth in your estate planning documents. When I say estate planning documents, I'm really referring to the trust. There are other ancillary documents, powers of attorney, advanced healthcare directives. I'm going to mainly focus on the trust and the administration of that trust for the purpose of this webinar. Okay. All right, so we're going to start with kind of a general outline of the legal requirements. A lot of times, this is something that our law firm would be handling on your behalf. A lot of times when clients try to do this on their own, they don't know the depth of it or the ramifications if done incorrectly. So I'm going to kind of go into detail a little bit about each one of these items so that you have an understanding when you walk away of what your successor trustee and the attorneys will be doing shortly after a loved one passes away. So first, it says update land records. Okay, so this would apply if a loved one passed away owning real property. If they had created a trust and they properly funded the trust, right? And that means actually transferring title. So for my house, if I purchase it in my name, Mark O'Brien, then I create a trust. I then transfer via a deed into my trust. So I do Mark O'Brien quitclaims as property to Mark O'Brien as trustee of the Mark O'Brien Trust. Right now, I've properly funded my trust. Upon my incapacity, though, or upon my death, we have to update the county recorder's office by filing an affidavit death of trustee or incapacity of trustee, right? This would allow my successor trustee to be put on title to help manage my real property, right? That means dealing with mortgage and lenders. That means dealing potentially with property taxes. That means dealing with utilities. That means dealing with a potential sale, right? If the beneficiaries want to sell it, once I've passed away, and there's really no other option but to sell the property, right? My successor trustee is on title. They can sign a purchase and sale agreement. They can negotiate the sale, so on and so forth. Again, same with my incapacity. Someone will be on title. If my property needs to be sold to take care of me, right, for my medical expenses, to help fund moving me into an assisted living facility. All of this would need to be done by updating the land records with the county recorder where the property is located. So if your house is in Los Angeles County, you'd be filing the affidavit with the county recorder's office. Next, we have to notify the county assessor's office. Usually these documents are done at the same time as the updating the land records, but the county assessor wants to know whenever there is a change in ownership. And the reason why they're so on top of this, and the reason why they wanted, and there's actually a deadline of 150 days, they're supposed to file this document. They want to know as quickly as possible whenever property transfers ownership, transfers hands, right? Because they want to reassess the property. They want to reassess it to the current fair market value, because that means higher property taxes. Higher property taxes means more revenue for the county. More revenue for the county means more revenue for the state. And anything that's revenue driven for the state or the county is going to be of the utmost importance. So for example, if I pass away and my trust says my 3 kids are the beneficiaries, the successor trustee that I've named will file a notice with the county assessor informing them that I have a trust and that my 3 children are the beneficiaries. And then they will reassess the property as of the fair market value for property tax purposes. There were a few exemptions that used to apply prior to 2021 that no longer apply because of Prop 19. So as a general rule, I just say almost 95+% of the time, the property is going to be reassessed. So just expect that when you're talking to your children or if you're having these conversations, and you're telling them, hey, I want, my desire is to keep the property in my family line, be aware that there most likely is going to be a reassessment. So if you purchased the property in 1970, and your assessed value is at a Prop 13, which was in 1975. So let's say the 1975 value is $50,000. And that's what your property taxes are based on. So you're paying a couple $100 a year in property taxes. You pass away in 2023. The trust it says the property goes to the 3 kids. It's going to get reassessed as of 2023. If your property's up north in San Jose area, San Francisco, if it's in Southern California, in over 2/3 of the state, the property is going to be probably worth $1 million or more. So just expect a huge reassessment. Like I said, there's a couple of exemptions. A lot of them do not apply anymore post Prop 19 in 2021. So it's something very good to be aware of and to plan for should you want your property to be kept in your estate when you pass away. So next, we have to notify the beneficiaries. Whenever a revocable trust becomes irrevocable, you have to give notice to all the trust beneficiaries and any heirs at law. So when I'm living, I create a trust. While I'm living, it's revocable. As long as I'm competent and have capacity, I can amend it, I can change it, I can revoke it whenever I please. The second I lose my capacity, right, I'm deemed incapacitated. Or once I pass away, the trust automatically becomes irrevocable. My beneficiaries, the successor trustee, any other family members, friends cannot amend it, cannot change it, cannot revoke it. So you have to give notice of that change in the character of the trust to the trust beneficiaries and heirs at law. The reason why that's very important is because beneficiaries and heirs have 3 years to contest the trust. If you give them appropriate notice, shrinks that 3-year period down to 120 days, providing quite a bit of a benefit to the trust in the estate. Next, we have to notify the California Department of Healthcare Services. So if your loved one was receiving Medi-Cal, we have to give notice to the state of California in case the state has any claims to recover any funds paid for Medi-Cal services. As a matter of practice for Copenbarger, we, even if a loved one is not receiving it, we still give notice for fraud purposes. We advise the state of California, this individual has passed away, even if they were not receiving Medi-Cal, please update your records to flag the social security number. That way, if anyone's trying to qualify for state benefits using that social security number, it'll automatically be flagged and triggered in their system. Next, the successor trustee has to lodge the last will and testament. This is an extremely out-of-date law. However, it still exists. Yeah, some other attorneys will say this was probably enacted decades and decades ago when people really only had a will, right? Not a lot of people had or utilized trusts. And the reason why we had to do this was you would lodge the original will within 30 days of death with the county court where the individual passed away. And then the court would hold on to that indefinitely. And the reason why they would do that is to protect the estate. If another family member came out of the woodwork and said, hey, I have another will and it says I get everything, now they have to go file that with the court and there's already the original will on file. So now they're going to have to overcome that will, which creates a barrier for them. Nowadays, most people have trusts. Everything's done outside of the court. So it's really, the will doesn't really have too much interplay, except for some rare instances. But you'll still lodge it with the court. No probate is being opened. You would just lodge it with the court, get a safekeeping receipt for the deposit and keep that for your records. Next, you have to obtain a taxpayer identification number. When someone passes away, as of their date of death, the social security number can no longer be used. So when someone passes away on today, December 14th, as of December 14th, can no longer use social security number. So you have to get a taxpayer identification number for the trust. Conversely, or for the probate estate, doesn't matter what type of administration, you'll still need some type of new taxpayer identification number. Any income earned from the date of death forward is going to be reported to that taxpayer identification number. Any expenses that get paid should be deducted from any account opened with that taxpayer identification number. And when tax returns are ultimately filed, you're going to be using that taxpayer identification number. Okay, lastly on this slide, we're going to give notice to the federal and state taxing authorities of a fiduciary relationship. Ultimately, in plain language, that just means we're going to send a notice to the IRS. We're going to send a notice to the California Franchise Tax Board. Unless you're you're out of state domicile and you're administering this out of the estate, you would send it to that particular state taxing authority. Assuming the person passed away in California, like I said, California Franchise Tax Board and the IRS, we're just going to be telling them, hey, this person has passed away, and this other person now, the successor trustee, is the acting fiduciary. So please send all communication, all correspondence to that individual, and also conversely, that individual has the authority to speak on behalf of the individual and or the individual's trust. Okay. Estate administration duties continued. This is all the trustee duties. This is the fun part. I'm not going to go through all of them today. Some of my colleagues like to go line by line here. I'm not gonna do that to you. I don't want to overwhelm you and put too much fear into you, especially if you've been named as a successor trustee. But once you become a successor trustee, numerous duties, fiduciary duties attached to you. What that means is you have all kinds of duties to abide by. You have all these legal statutory laws that you must abide by, right? So the most common and one of the most important is the first one. Just want to take a step back here where it says probate code and then a number. That's just a specific statute that's referenced in California law. So if you were to look up the California probate code, section 16,000, that's the specific law saying it's a duty to administer the trust. That's the most important. As a successor trustee, your duty is to administer the trust. People will say, what does that mean, in a reality, a practical sense? It means when you read the trust, you have to abide by the terms of the trust. If the trust says at the end of the administration, certain amount of cash, $100,000 goes to person A, $100,000 goes to person B, and the remainder of the estate, after the expenses and taxes are all paid and everything's taken care of, goes to the City of Hope, right? Once you're done administering the trust, it is your duty to make those distributions to those people and to that entity. If the trust says, I want to create a special needs trust for my child, who has autism and qualifies for state and federal benefits. It's my duty to follow the terms of the trust, and abide by that special needs trust that was created within the trust, and then continue to manage that trust, from an ongoing standpoint for the benefit of that special needs beneficiary. That's assuming that I'm the trustee of that trust for these purposes. So yeah, that's the most important aspect, is the duty to administer the trust. I'm going to touch on a couple other duties here, just because I feel like it's important to just cover them. Duty of loyalty. What does that really mean, other than the plain language? Essentially, what that means is, and the best example I can give is, if I have 3 children and I go, there's child A, child B, child C, and I name all 3 equally as my beneficiaries. And I go, you know what, child A is the oldest. Not only are they the oldest, they are a CPA. They have numerous experience. They've actually been named as trustees for other people's trusts, and they've administered other people's trusts, so they have a lot of experience in this area. I'm naming them as my successor trustee because that's the prudent decision to make. Not only that, the other 2 siblings seem to be in line and agreeable with the naming of that individual, that child, as the trustee, right? That trustee is now wearing 2 hats. On the one hand, they're a trustee, but on the other hand, they're a beneficiary, right? So if they treat themselves better, right, or they take opportunities away from the trust, or to the benefit or to the negative, the detriment of the child B and child C, right, that would be breaching my duty, that child's duty of loyalty. They need to treat everybody impartially. That kind of goes in line with the next duty to deal impartially beneficiaries. I have to treat everyone equally. If I want to make, if child A, B, and C are equal beneficiaries, right, each gets 1/3. And I want to make, let's say I'm administering the trust. We're not really necessarily near the end of the administration. There's still expenses. I'm still doing taxes. There's still some creditors. I'm still selling the property. But let's say I have $1 million in cash accounts, that are well above any of the expenses that I anticipate, well above the taxes. And I go, you know what? I want to get some cash to the beneficiaries. I can't make a preliminary distribution to myself for $100,000 and then distribute 10,000 to child B and 10,000 to child C, right? Clearly, I just favored myself. That would be a breach of both the duty of loyalty and the duty to treat the beneficiaries impartially, right? I need to make a $10,000 distribution to all 3 of us, or a $50,000 distribution to all 3 of us, or don't make a preliminary distribution at all. So those are kind of straightforward, kind of common sense. I'm going to kind of go through the rest of these here. Not too many of them are important. Duty to diversify just means, there's something called the prudent investor rule. It just means whenever you're administering trust, take a look at the assets. If it's just a cash account and real property, really there's no true reason to diversify. But if there's investment accounts and prior to death, there was an aggressive investment strategy, it's a good idea to have a sit down with the attorney and the advisor and go, okay, what's the best outlook here? How long is this administration going to go, and what's going to protect the assets while also diversifying them to protect against spikes in the market? What can we do to kind of equal things out and make sure that we're not breaching this particular duty? Lastly, the 2 most important ones are the general duty to provide information to the beneficiaries. And this kind of goes hand in hand with the duty to account to the beneficiaries. A lot of times, a lot of issues come up in administrations merely because the trustee doesn't communicate, doesn't provide reasonable information or updates to the beneficiaries. The trustee could be over here doing everything right. They could have met with the attorney. They could have done all the legal requirements we talked about. They've done all the notices. They are currently dealing with the taxes. They're paying off any of the final expenses. They're selling the real property. They're protecting the assets. They're doing everything they're supposed to be doing, right? But 3 months have passed from the date of death, and they haven't sent a single email, haven't picked up the phone and called a single time. They saw the other family members at the funeral or the service, and that was it, right? And they made no mention of the trust, no mention of the administration. The only reason why the beneficiaries know is because they got the notices in the mail with copies of the trust and so on. Excuse me. Right. So to try to take away from that, when beneficiaries don't hear from the trustee, that's when they get worried. That's when they get concerned. That's when they go get their own counsel and they go, okay, what's going on? That's when those thoughts start to creep into their mind. Okay, is what's supposed to be done actually being done? And is this person trustworthy? Again, most of the time the person is trustworthy, but they don't know that because they have no information. So your general duty as a successor trustee, give them updates, right? Every 3 to 4 weeks or whatever is reasonable based on your conversation with the attorney. Tell them what's going on. Hey, we're in the process of selling the real property. Here's the price that has been agreed upon. Here's a current account statement of the trust account for your reference. Sometimes you may even say, here's an inventory of the assets. It just really depends on case by case, family by family of what giving reasonable information looks like. But it's always good to just in general provide, at least at a minimum, an update of where you are, and some expected timelines and maybe some issues if there's anything going on that's holding up the administration. You can always tell them that so that they're aware. That way they're not constantly calling, going, what's going on, where's the money at, where's my distribution, because ultimately that's going to be what happens. Or if the nuclear option is they file an action with the court demanding an accounting, demanding your removal, and so on and so forth. Lastly, duty to account, similar, but this is really more a right to the beneficiaries. A trust can say, I'll take a step back. A trust sometimes says, so if I create a trust and I put language in the trust that says, the trustee can waive an accounting, right? That would actually be against public policy, and the law would strike that provision from my trust. Only a beneficiary can waive. So to go back to the example where I've named my 3 children as the beneficiaries. I've passed away. Child A is now administering my trust. At the end, right, he or she has a duty to account for all the actions that have occurred from my date of death until final distributions. What that looks like is all the receipts, all the income, all the expenses, all the expenditures, all the disbursements, any preliminary distributions, all the asset values as of the date of death, potentially asset values on hand, prior to making preliminary distribution, what anticipated taxes there are, any sales, any gains or losses, in profit on those sales. A whole host of information goes in that account. It is an expensive and lengthy process, but the beneficiaries can waive that. So if all 3 of those beneficiaries go, you know what, we're satisfied with your job as trustee, we will sign a waiver of account. That way we can forego that process. However, all beneficiaries must sign that, and they must have to sign that in writing. Otherwise, that period goes on indefinitely. So I could distribute the assets, and the beneficiaries could come back and be like, 2.5 years later, be like, I'm challenging your actions, and they would actually have a legal ground to stand on, and they could file something with the court. So that's something you don't want to avoid. So ultimately, by giving updates, by giving the reasonable information, you're going to be negating a lot of future conflicts, while actually showing that you are trustworthy and that you are administering the trust and doing the other duties that you're supposed to be doing. Like I said, a lot of these tie into each other. For the rest of these, again, these are all the California state set laws for trustee duties. The trust itself can put other duties. If there's an instance where the trust says other things, and as long as it's not against public policy and it's not illegal, then the trust would control. So there may be other duties. Conversely, the trust may give the trustee additional powers, right? Again, as long as it's not against public policy, and as long as it's not illegal, certainly that's okay. That's really a conversation for the attorney who's drafting the estate plan and the person who's creating it to have at that time. Okay, next, taxes. The most fun aspect of an administration. I say that with the utmost sarcasm. I think that everyone here generally has a consensus that taxes are the bane, and are the the evil of our society. We'll kind of just briefly go through this in each one. I don't want to get into too much detail, just because there isn't a specific case in front of me to kind of lean on. Personal income tax returns. So when someone passes away, you have to file a final personal individual tax return, right? And putting a trust together and naming a successor trustee is very important, because that person is going to be handling all of these tax matters. So if someone passes away in December of 2023, that successor trustee would be filing a final return for 2023. Excuse me. And that And that tax return would be due April 15th, 2024, just like it normally is, right? And that's your typical, your California Franchise Tax Board Form 540 and your IRS Form 1040. Really, there's not too many aspects of the individual tax return that are that complex. If your family member was using a particular CPA or accountant, it's always best to go to that person because they have that information. Conversely, if they were not, we actually have CPA attorneys in our offices. We're more than happy to help with preparation of these tax returns if desired or necessary. Next, fiduciary income tax returns. So we had, I kind of briefly mentioned this earlier, right? One of the legal requirements is you have to get a taxpayer identification number, right? From the date of death onward, you can no longer use a social security number. We have to use the taxpayer identification number for the trust. And if it's a probate, for the estate. Doesn't really matter for the purposes of our conversation. Regardless, there's going to be a new taxpayer identification number. Once you obtain that taxpayer identification number, the IRS is going to know that there's a trust or estate. And what that's going to trigger is a fiduciary tax return due date. From the date of death until distribution, you're going to have to filing a trust income tax return or a probate estate income tax return. Again, the executor that's named in the will or the trustee that's named in the trust or any other court-appointed person representative, if it's a judicial administration, will be handling these tax returns, right? So any income earned by the trust estate or by the probate estate from the date of death until final distribution will be date with on these returns. However, I always suggest that, and it's very prudent to meet with a professional who understands these returns. Sometimes you have clients who will say, I do TurboTax and I'm going to try to do this myself. I would suggest and advise against that. There are numerous deductions that are applicable and tax saving strategies that can be applied to these types of returns. So it's always best that you meet with a CPA or an attorney or a tax professional to go over that so you can capture those benefits and save the estate and the trust from additional expenses that are not necessary. Estate tax returns. So this term gets confused a couple of times. You've heard me say probate estate. This is different in that it's federal estate tax. That's a whole separate tax. Sometimes it's a hot button political item. So you hear it a lot, especially with the presidential campaigns coming up. A lot of times you've heard it in the midterms. A lot of times you'll hear it in these ones. Even at the local level, sometimes it's hotly debated. This is what you have probably heard as the death tax or potentially the inheritance tax, right? Is the government going to tax me when I pass away and I want to transfer assets to my heirs? So this has nothing necessarily to do with income, like we just talked about at the personal income and the trust income. This solely has to do with the transfer from generation 1 to generation 2, or to your heirs, essentially whoever your heirs consist of. Currently, in 2023, each individual can pass up to almost 13 million of assets estate tax free. What that means is as long as you're below that threshold and you've passed away in 2023, your heirs, your successor trustee does not have to pay tax, this particular tax, let me be clear, does not have to pay federal estate tax, and does not have to file a federal estate tax return. So you may be going, why are we even talking about this? If it's 13 million, this really doesn't apply to, and if it's a married couple, now we're talking 26 million for the combined exclusion for them. That is because in 2026, these thresholds are going to revert to old thresholds. In 2026, it's going to revert to 5 million per person. So although this may not apply to a ton of people, that's going to open up to quite a bit more. On top of that, and this is what I always tell clients, especially when I'm doing estate plan or trust administration, is that this law is not something that's set in stone, right? It's changed over the years. It's been increased over the past decade plus, but there are times before that when it was almost non-existent. So depending on who's in office, president-wise, and who's in Congress, right, with the makeup of Congress, they can change this, right? 5 years, 6 years from now, 2026 is gone and past. 2031, Congress can go, you know what? We don't want an exemption at all. So that 5 million per person, adjusted for inflation, right? That exemption, it's gone, right? We're going to make it zero. That means if you have $1 in your name as your death and you transfer that to your children, it's going to be taxed for federal estate tax purposes. Currently, it's a 40% tax. So if you had $1 to your name, transfer to your kids, they're going to get 60 cents. 40 cents is going to go to the government. So at any time we can avoid, let me take a step back, legally avoid, having to pay additional taxes when we can legally and lawfully do so. We like to plan for such. And that kind of puts me into this next part of the slide here, estate tax portability election. This is for spouses and spouses only. The IRS has actually created a mechanism that benefits us tax-wise if you are a surviving spouse. So if you, I'm going to use an example and some numbers here so you can see what that looks like. The IRS allows the surviving spouse to use any unused portion of their decedent spouse's exemption and to port it, right, to put it in their own estate when they die. So an example, right, if you have a spouse that passes away in 2023, the exemption is 13 million for all purposes, right? But let's say the total estate is 2 or 3 million, right? That means that the spouse that's passed away didn't use anywhere near their 13 million, right? The surviving spouse can elect to file this estate tax return with the government solely for portability purposes. So let's say the spouse that died has 11 million in exemption that they did not use, right? The surviving spouse files that election. Now they get to transfer that 11 million into their own estate, and that's grandfathered in. It's locked in. So we go back to 2023, right? Fast forward. Congress has wiped out the 13, the 5, the later 5 million exemptions. No exemption, right? Any assets that transfer upon death are taxable. That spouse filed that portability election and they locked that 11 million in. So as long as their assets are below that, and as long as their lifetime gifts were below that, their heirs are not going to pay any federal estate tax. So there is no downside to filing that return other than simply the cost of preparing it. But that's only for surviving spouses. Next, we have income tax basis, right? So this is the basis. A great example is if I purchased Apple stock for $1, I sell it for $100 a share, right? That's $99 a share of profit. When someone passes away, in most instances, the beneficiaries will get a stepped up basis. So go back to that example, right? I purchased it for $100 a share. I pass away and it's valued at $100 a share. And my successor trustee sells it for $100 a share. No profit, right? It was valued. Now the step-up basis is $100 a share, sold for $100 a share. That's a $0 wash, no gain, right? So my beneficiaries will get that stepped-up basis as of my date of death. This is a huge capital gains tax savings benefit to the heirs of my estate. And lastly, property taxes. Kind of already touched on that. Whenever someone passes away in California with property in California, the assessor is going to reassess the property as of date of death, and that's going to be the new property tax base for property taxes moving forward. Again, there used to be exemptions, but I'm not going to go into them because they're very narrow now, and most people do not qualify for them. If you want to go look into that further, Prop 19 is the controlling law that changed that as of 2021. Okay, transfer of assets. This is how the assets ultimately transfer. The attorney will walk you, the successor trustee, through these. Solely owned property. This is something if I had an account, I left it in my name, right? It's in my name, not in the trust. I don't have a joint owner on it. I don't have a beneficiary on it. That's a probate asset when I pass away. So the real key here is put the assets in the trust. That is the most important aspect for creating a trust, is create the trust, fund the trust. And that's where a lot of people fall through. They create the trust and then don't fund it. It was pointless. There was no reason to create the trust if you're not ultimately funding it. Jointly owned property. This is a little different. If I own an account with one of you, right? So my name and in your name, when I pass away, it automatically transfers to you. And vice versa, right? If you pass away, it automatically transfers to me. This would happen outside of the trust. Beneficiary designated property. This is typically like a retirement plan, life insurance, right? If I have a life insurance policy on myself and I name one of you as my beneficiary, when I pass away, you would give the life insurance company the death certificate, and they would send you claim forms, and they would pay out the claim to you. Just be aware that we typically advise to name the trust as a beneficiary of life insurance policy. What if I name you as a beneficiary and you become incapacitated, right? And you don't have an estate plan, and now your estate's going through a conservatorship and all kinds of issues are created. So please consult with, the attorney, the estate planning attorney, or our office when naming beneficiaries on retirement accounts, on annuities, on pensions, on any type of account that has a beneficiary. Please make sure you're consulting so that you can do it appropriately. If there is no trust and someone has a will, or if someone passes away without a trust and a will, it has to go through probate. As we kind of talked about, probate is just a court supervised administration. And I'll kind of go into the differences a little after this. Okay, some of the timelines here. This is kind of just a general overview of really, kind of a step-by-step analysis of what happens when someone passes away, right? Someone's become incapacitated or passed away. That's first what happens. Second, you're taking the time to care for the family, and to grieve and to deal with the funeral and contacting, family members and others to get together and deal with the service and so on. After you've done that, it's kind of going through trying to find estate planning documents, trying to find copies of bank account statements and credit card debts, dealing with utilities bills and mortgages, right? And then calling the attorney's office to say, hey, my loved one has become incapacitated. I know that they have a trust and a power of attorney, and what's the next steps? And at that time, you schedule an appointment. And then during that time, in between the appointment and the actual meeting, when you scheduled it, you'd gather everything and then bring that into the attorney's office to kind of sit down and go over the next steps. Okay, this is a probate process timeline. Okay, on average, at a minimum, we're going to say 18 to 24 months. Everything got backed up because of COVID. Almost every county is backed up as far as they're short-staffed. They have a huge backlog in processing documents. Not only that, there are court hearings that have to be set at various stages. Each hearing can take anywhere from 4 to 6 weeks to be set, can take up to 5, 6, 7 months to be set. And there are multiple of these that have to occur in a probate administration. That's a huge downside to this. Another huge downside is the controls with the court, right? Everything has to be done through the court, right? It's a court supervised administration. They are going to be supervising, they're going to be overviewing, you're going to have to do things to their liking, right? To the state of California's liking, to the county's liking, to that specific department, that courthouse department's desires and rules. So there's a lot less flexibility for your loved ones and family members. Not to mention, everything is public, right? Everything that's filed with the court, or I should say 99% of it, is public record. So if you have creditors, if you have debtors, if you have people who are just generally trying to look into your estate, they will be able to pull the court case docket, pay some minimal fees, and pull those documents. So those are a huge downside. Another huge benefit to having a trust is the privacy, but the control within the family. A huge aspect of probate that a lot of people have potentially heard about is the fees. So in California, and I'll kind of go to the next slide here. In California, our legislature, right, our own Congress our assembly has created a statutory fee schedule for probate. In plain English, what that means is our fees, the attorney's fees, are based on the size of the estate. So in California, if you're looking at the example on the slides right now, if a median home is $1 million, right, and we kind of just took this for math purposes, but it's probably not too far off nowadays, right? These are the fees that would apply based on that percentage, that attorney fee compensation schedule that the state of California has set. So we're looking at $23,000 in fees, in attorney's fees alone. The executor, the administrator, right, the personal representative who's been appointed to administer the estate is entitled to the same amount of fees. So if they decide to take their fees, right there, you've already expended $46,000. And then these remaining expenses are all expenses that are incurred in every single probate. So every one of these, sorry, apologies, I just went to the wrong one. There you go. All those expenses are going to be almost guaranteed. Now, they may vary as far as the amounts for the probate referee and the filing fees and the publication costs, but they're generally within this range. So if you look at this total approximate cost, $50,000, 500 for the probate administration. Generally, estate plans are nowhere near this. On top of that, if you update, every 3 to 4 or 5 years, you update your estate plan 2, 3, 4 times, you still wouldn't even come close to this number. So doing an estate plan really saves, a ton in costs and expenses. Like I said, the privacy factor, the control factor And the ability to write it, kind of give your successor trustee much more flexibility. All right, so the trust process timeline. A little bit shorter of a timeline. I would say anywhere, 12 months plus or minus a couple of months is the general average. Sometimes it's done quicker, sometimes a little bit longer, just depending on the family dynamics. But again, the most important aspect, control is within the family, right? The trust governs. The trust says what the trustee powers are, what the trustee duties are, and the successor trustee is the one who's managing the estate, marshaling the assets, handling the control, has a lot more flexibility, a lot more discretion. As far as the fees go, right, huge saving compared to probate. Most of the time, administration fees are done on an hourly basis, and that, based on the attorney's hourly rate. Again, even if it's, the attorney has a high hourly rate, it's still not going to come close to the 50,000, I think, or so on the last slide. So there's quite a bit of savings as far as fees. There's quite a bit of savings time-wise, right? Time is money, right? Especially when you're grieving, especially when you have your own life going on. If you're the successor trustee, you're not going to want to be doing this forever. And I know probate estates that go on for years and years because of family complications. So yeah, these are just kind of some huge benefits to just a timeline perspective of why a trust is so important, and also to give you kind of a general overview of what to anticipate when a loved one becomes incapacitated or passes away. All right, communication expectations. Kind of harped on this from the very beginning. Communication is key, right? A lot of issues can be resolved and or completely negated from the get-go by just communicating. I know that sometimes it's hard because sometimes we have family members who don't get along prior to this. But even if that's the case, right, your duty as successor trustee is to be objective, and to administer the trust. That's one of the duties, to follow that. You can negate a potential lawsuit in the future solely by giving not weekly, but every 3-4 weeks or every couple months, whatever the appropriate time is based on that particular scenario, and keeping the beneficiaries in the loop, right? You don't have to give them every minute detail, but you can give them the general overview of where you're at and any major material transactions that are occurring. Okay, so I'm kind of wrapping up how we can help, right? This is kind of just an overview of what to think about when you are ready to reach out to an estate planning attorney. What matters most to you? Is it your legacy? Is it your charitable donations? Is it setting up your children to have a comfortable life, for the remainder of their lives? Is it to provide for your grandchildren's education? Do you have beneficiaries who have addiction and chemical dependency problems, right? Do we want to make sure they don't get in control of a bunch of funds and assets that's going to continue them down that path, right? We want to make sure that we're doing the most that we can to negate that and to help them alleviate that, right? To help them change course and to get better and to get healthy. So really, trying to think about what's important to you. Sometimes people really want to protect their estate from taxes, right? So maybe the taxes are the most important aspect of their estate planning, right? Who is going to be responsible, right? Who do you want to be in charge of everything? Who's the most, who's the most prudent person to name? And that may be an ongoing conversation, right? The most prudent person today may not be the most prudent person in 6 years. Your child who you thought was the best may change, right? They may have married someone, have kids, and things have gone down the hill, or better yet, maybe everything's great, but they moved to New York, right? They're no longer physically close. Or maybe they have too much going along in their life and they just don't have the bandwidth or capacity to do the administration. So it's always good to keep that as a revolving conversation with yourself, with your family members, and with the attorneys. And then also funeral expenses, right? A lot of times funeral happens before your successor trustee or your family members meet with the attorney, right? How do we pay, how do we provide for that gap between the taking control of the estate and prepaying some of the expenses so that your beneficiaries and heirs and families don't have to come out of pocket. Okay, and this kind of goes along with that, right? We can give you all the tools and resources necessary for conservatorships, estate administrations, helping those with special needs, and all of the transactions and all of the kind of inner workings that go along with that. And again, all of these things, and that's why this is bolded. Doing this while you're alive and have full capacity is the end goal. It's the target, right? You don't want to be scrambling. You don't want to be doing things when there's a potential of incapacity or when others are involved. I mean, there's, you've probably heard worst case scenarios of undue influence and people getting involved when they shouldn't be and having control when they shouldn't be. Doing this all well in advance, plans for all of those contingencies. Okay, and these are just some other facts about our firm, when we've been open, how many attorneys we have on board, kind of our specialties and other qualifications that we have and our experience in our staff and locations. A huge aspect of this, I just want to remind everyone that's joined us today, you're going to receive an automated phone call from us asking if you are interested in setting up an appointment. So just be aware, you'll be getting an automated call. So if you see one, it's not spam. I know that everyone's worried about these days, and rightfully so. I have gotten 3 spam calls during this webinar alone. So yeah, just be aware, automated phone call. A lot of things I talked about in general. If you have specific questions and you want to set up a meeting with an estate planning attorney, a state administration attorney, and if you have a plan that you want to be putting in place, or you want to review a plan, or you have a loved one who's passed away and you have some questions and may need some representation or at least some guidance. You may not ultimately retain us, but at least you have some questions, or so you may need just the comfort of us telling you that things are going along smoothly, whatever that really ultimately looks like on a case-by-case scenario. Feel free to respond to that automated message, and we'll go ahead and set up an appointment for you, okay? All right. Thank you very much, everyone, for attending today. I think we're pretty close to the hour. This is all of our contact information. You can call anytime, visit our website. You can book on there. You can email us. Really, please, this digital evaluation, very important to us. Okay, please check the link in the chat. So if you go to the chat on your Zoom, it should be at the bottom on the controls tabs or on the side of the top, depending if you've moved it. Please fill out the digital evaluation. Let me know how I did. Let me know about the slides. Let us know about the presentation. This is how we kind of tailor our presentation to make sure we're providing the best benefit to our clients, to you, to any other providers and services that we're and any other professionals or advisors that we're doing this for. We want to make sure we're giving the best information. We want to make sure that we're explaining everything very clearly and that we're doing it in a manner that's digestible and that you're understanding and that you're getting a good overview of what's going on. Putting all that in there, whether it's good, whether it's bad, anything is okay. We look at it all, and we are constantly trying to update this webinar to improve it. All right, because if we improve it, 1, that helps us get better. 2, it helps our clients and their own situation better, and also get better information out there. So please go ahead and fill out the digital evaluation, and we take any and all, any positive feedback, any constructive criticism. We take that very, very strongly here, and we appreciate it quite a bit. So with that being said, thank you again for joining us today. I'm going to go ahead and leave it on here for a while. If you had questions in the chat, I think we may have a second or two. I'll try to look right here. Give us 1 second while I'm looking through here. Okay, great question. My husband and I have a revocable trust. He has passed away. Does his portion of the trust become irrevocable? And you'll see that a lot of attorneys will do this. It depends. It depends. Without seeing what the trust says, the trust could say that everything goes to the survivor. In that case, it would not be irrevocable, right? But it could say that the trust is divided. So it could be that portions of the trust are irrevocable. It could be that the entire trust is irrevocable. So yeah, that's something that you'd have to have an attorney go through the entire trust and review it itself. And that will be ultimately where you can get a more clear answer on that. Great question, though. Just depends on what the trust says when it was created. Gonna go to some other. I have a time for maybe another 1 or 2 questions here. Is there a minimum amount estate total that goes into probate? Great question. Yes, in California, the threshold is $184,500. Don't ask me why they chose that value. They take a couple of the last 5 years of their CPI reports and other metrics that they do to come up with this value. In my opinion, it's way too low. Your median house alone would dwarf that. So if you have a house and it's in your name and it goes to probate, almost automatically, you have a probate unless you have a trust and the property was there. So 184,500. The calculation for that has to be probate assets, right? So if you have a trust and you funded the trust, any assets that are in that trust do not go to that calculation. But if you left out a couple of vehicles and you have a couple of accounts and you forgot to name a beneficiary on a life insurance, now you're at 400,000. Yes, you would need a probate in that instance. Part two of the question, what happens to the estate that falls under this minimum amount? There are other ways to administer via the courts and outside the courts. Too complex of a question to answer. We have to have a complete picture of the estate to really give an answer because there's so many different articulations of that. But again, a great answer. If you're dealing with an estate, please feel free to give us a call. We could sit down and go over all the assets and title to all the assets and kind of give you a more directed answer in that regard. Otherwise, that's my time today, everyone. Again, thank you so much for joining us today. Taking time out of your busy lives to be here. Hopefully you gain some valuable knowledge. And again, please fill out the digital evaluation and reach out to us at any time. Thank you and have a great day, okay?